So, I miss the UK. I miss parts of the UK, of course I do. And I think that it's really quite sad that I won't be able to show, my children my homeland.
The air turned thick as every gaze locked onto Prince Harry. A moment designed for clarity suddenly became unforgettable. Under oath, a judge posed a question so elementary it should have slipped by unnoticed: the birth dates of his own children. Time stretched, composure fractured. Cameras captured disbelief washing through the room as Harry searched for answers, sparking whispers, questions, and headlines across the globe. Was this an innocent mistake? Or something far more troubling lurking behind the hesitation that altered everything permanently, carved into royal history and collective consciousness? A stillness that thundered louder than any sworn statement? The question arrived without theatrics or blame. It came quietly, almost procedurally, delivered in the measured tone of a judge whose purpose was not to provoke, but to confirm. Within one of Britain's most guarded courtrooms, on a grey Monday morning in London, Prince Harry sat under oath as a plaintiff. Not royalty, not a public personality issuing declarations, but a man legally obligated to respond truthfully. The judge glanced at the documents, turned a sheet, and asked him to verify the complete birth dates of his two children, Archie and Lilibet. It formed part of standard identity confirmation protocol, the sort of inquiry meant to establish certainty in testimony before deeper issues emerge. In that space, the anticipation was instant, not because the question invaded privacy, but because it was fundamental. Parents provide such information reflexively without pausing, without searching, particularly here, where every utterance held legal significance and every reply was documented, preserved, and examined for truthfulness. This was not informal dialogue. This was sworn evidence, and sworn evidence permits no approximation, no improvisation, no stalling. Yet the response never arrived. Initially, the quiet was nearly imperceptible, merely a heartbeat where nobody recognized something had shifted. Then it expanded long enough for awareness to sharpen, long enough for writing to cease, long enough for the atmosphere in the chamber to palpably transform. Prince Harry blinked, looked down, adjusted himself slightly in his chair. The judge remained patient. Nobody intervened. No attorney stepped forward to explain. The silence persisted, no longer neutral, no longer benign. This was not the kind of quiet that suggests confusion. In court, silence carries meaning. It signals uncertainty, doubt, deliberation, or danger. And under oath, danger is never theoretical. Every postponement creates room for suspicion. And suspicion is the one thing a plaintiff cannot risk when trustworthiness forms the foundation of the entire case. This was not aggressive questioning or a calculated trap designed to ensnare him. It was a routine inquiry, one structured to be addressed smoothly so proceedings could advance. Instead, the moment froze. Those observing did not react audibly or visibly. Courtrooms seldom respond that way. The transformation was quieter, more disturbing. A subtle tension here, a focused stillness there. The collective awareness that something anticipated had failed to materialize. For a man whose legal fight relied on confidence in his version of reality, the uncertainty felt profound, almost emblematic, as though a fracture had momentarily surfaced before anyone was prepared to acknowledge it. Eventually, the answer still did not come. The dates remained unspoken. The court proceeded, but the harm was already inflicted because the record preserves more than language. It preserves rhythm, assurance, and the voids between them. That pause could not be deleted, revised, or justified in real time. It remained there embedded in the proceedings, indicating the first breach in what was intended to be a measured, precisely presented argument. In a courtroom, silence does not signal confusion. It signals danger. And from that instant onward, every statement that followed would be interpreted through the shadow of the one that required too long to surface. So, what do you believe that single frozen stillness exposed about Harry? And could it quietly reshape the trajectory of his entire legal battle? Stay with us. The moment silence turned treacherous. The pause did not conclude swiftly. What had started as brief uncertainty now settled into something weightier, something unmistakably critical. Prince Harry was not simply addressing a routine question. He was sworn in, positioned under oath in a sealed London courtroom, completely aware that every phrase and every omission carried legal ramifications. This was a bench trial, not a media circus, and the standards were merciless. Truth was not evaluated by sentiment here, but by precision, consistency, and accuracy. And under those circumstances, hesitation transforms into something else entirely. The judge did not elevate his tone. There was no apparent irritation, no cutting reprimand. Instead, the question was quietly restated exactly as before. A procedural reset designed to offer the witness a clear chance to answer. Can you verify the complete birth dates of your children? The repetition itself altered the dynamic. In court, when a judge repeats the same question, it indicates that the response matters more than initially assumed. This was not about interest. It was about confirmation, identity, dependability. Prince Harry's body responded before his words could. He blinked deliberately as though purchasing time. His eyes fell to the surface before him. His posture shifted, a minor adjustment that revealed tension beneath the rehearsed calm. These movements were small, almost invisible, but in a courtroom, they communicated volumes. Legal teams registered them. Judges registered them. Silence combined with visible discomfort begins to construct its own narrative. And still, no definitive answer emerged. This is the moment legal professionals dread most, an unplanned void. Courts function on preparation. Statements are drafted, examined, refined. Witnesses are guided not on what to express, but on how to remain within what they understand. When a witness falters on a foundational inquiry, something nobody predicted, authority dissolves. There is no objection to raise against silence, no document to cite, no counsel permitted to intervene. The witness stands alone with the question. What made the moment especially precarious was what it implied. This was not a complex date buried in decades-old records. These were the birth dates of his own children, Archie and Lilibet, details that anchor his public identity as a father and guardian. Under oath, failing to deliver that information clearly was no longer a human error. It became a legal weakness. Perjury does not demand intent in the way the public often assumes. Courts scrutinize accuracy, certainty, and consistency. A witness who cannot verify basic facts introduces doubt into everything that comes next. Even if an answer ultimately appears, the initial failure does not vanish. It remains part of the official record, unchangeable, existing between the lines of the transcript. Judges do not merely hear what is stated, they remember how it was stated and how long it required to state it. At that moment, this was no longer solely about memory. It was about credibility, fracturing in real time. The silence lingered precisely long enough to alter how the room listened. From that point forward, every assertion Harry would offer, every claim about sequences and consequences would be filtered through this uncertainty. The case had not yet reached its central arguments, but something fundamental had already transformed, and the pressure, once it started to accumulate, demonstrated no sign of diminishing. Now, what fractures will this hesitation reveal in Harry's case? And could one unanswered inquiry change everything? Stay glued, returning to a place he once attempted to escape. To comprehend why that silence in the courtroom carried such weight, you must step back to the beginning of the day. Monday morning in London did not feel like a return for justice. It felt like a return to judgment. Prince Harry arrived discreetly without fanfare, without the protective barriers that once characterized every public appearance he made in this country. There was no Meghan beside him, no comforting presence, no meticulously arranged moments for the cameras because there were no cameras permitted. This was not a royal appearance, and it was not a media spectacle. It was a consequence. The location itself mattered. The Supreme Court of the United Kingdom is not a venue of theater. Its substantial wooden doors and subdued architecture are constructed to remove emotion from the space and leave only evidence behind. This was the same system Harry had criticized for years, the same institutions he accused of failing to shield his family. And yet, here he was walking straight back into it, willingly placing his story, his memory, and his credibility into its grasp. As he stepped inside, reporters captured only fleeting glimpses. There were no smiles, no acknowledgments, no recognition. He did not pause. He did not survey his surroundings. He moved forward with a rigidity that felt less like confidence and more like survival. Dressed plainly in dark gray without decorations or emblems, there was little remaining of the royal image the world once recognized. What remained was posture trained long ago, holding together a man who appeared emotionally removed from the moment unfolding around him. That distance was remarkable. It was not fear that displayed on his face, but something closer to disconnection. Almost as if he had already accepted that whatever transpired inside that courtroom was beyond his influence. This was not the body language of someone preparing to prevail in an argument. It was the body language of someone bracing himself to endure it, as though survival, not victory, had become the unspoken objective. This trial was not Harry's first legal confrontation with the British press, but it carried a different gravity. It was the final chapter in a lengthy series of lawsuits aimed at challenging the tabloid apparatus he believed had shaped and harmed his existence. Each case before this had eroded his sense of security, his confidence in institutions, and his belief that telling his story could still recover something lost. Now standing alone inside the very system he once condemned, the cost of that belief was becoming visible. When memory becomes the weakest link, by the time the court settled into its rhythm, it was already evident that this case would not hinge on a single document or one explosive disclosure. Its foundation was far more delicate. What Prince Harry had brought before the court was a story constructed on patterns, timelines, and recollections. A long chain of moments he claimed proved sustained intrusion by the British tabloid press. But at its foundation, this was not a case driven by physical evidence alone. It was driven by memory. That distinction matters. This was not a jury trial where emotion can sometimes influence the room. This was a judge-only proceeding, where credibility is examined slowly, methodically, and without sentiment. Every claim had to align, not simply with documents, but with consistent recollection. Dates had to make sense. Sequences had to hold. One moment had to logically lead to the next. And in a case like this, where years of alleged intrusion were being revisited, memory was not simply supporting the argument, it was carrying it. The legal pressure intensified as that reality settled in. Each question posed to Harry was part of a larger verification process designed to test whether his account could withstand scrutiny. Judges do not only listen for what happened, they listen for how clearly a witness remembers it. Certainty suggests truth, hesitation invites doubt, and once doubt enters the room, it does not stay confined to a single answer. That is why the earlier pause over his children's birth dates mattered so profoundly. It was not damaging because of what the question asked, but because of what it revealed. If a witness hesitates on a foundational fact, something deeply personal and seemingly unforgettable, it forces the court to reconsider how much weight to place on more complex memories. Timelines involving media articles, private conversations, or alleged surveillance suddenly feel less solid when the simplest details falter. When his own words turned against him, the courtroom had already absorbed the tension of hesitation and doubt when the proceedings moved into a quieter, more intimate phase. Prince Harry was asked to read aloud from his own witness statement, a document carefully prepared, reviewed, and submitted as part of his case. On paper, these were his words chosen to explain the emotional toll of years spent under relentless media scrutiny. Spoken aloud under oath, however, they took on a different weight. This was no longer a lawyer summarizing his experience. This was Harry himself, forced to confront his own account in real time. At first, his voice was steady, measured, controlled. He read the opening lines with the composure of someone accustomed to public speaking, someone trained to deliver difficult messages without betraying too much emotion. The courtroom listened closely, not because the words were new, but because context had changed. After the earlier silence, after the visible struggle to answer basic questions, every sentence now carried added significance. Then he reached the passage about memory. The pacing slowed almost instinctively, as if he sensed what was coming before he spoke it. The words described how ongoing trauma, constant intrusion, and fear had affected his ability to form consistent memories during the early days of his children's lives. As he read, his voice faltered. Not dramatically, not enough to stop him, but enough to be noticed. A slight crack, a pause between phrases. The kind of hesitation that does not come from reading difficulty, but from recognition. In that moment, the earlier pause over his children's birth dates took on a new meaning. What had seemed inexplicable now appeared connected. This was no longer framed as a simple failure to recall a detail under pressure. It was being reframed, by his own words, as part of a broader struggle with clarity. The silence in response to the judge's question was no longer an isolated incident. It became a symptom. The contradiction was stark. Publicly, Harry had built a post-royal identity around being a fiercely protective father, a man who had uprooted his life to shield his children from the harm he believed the media had caused him. Yet here, under oath, he was acknowledging that those early moments many parents recall with sharp detail, were blurred for him, the calm voice that shifted the balance. By the time the next witness was called, the atmosphere in the courtroom had changed again, this time tightening rather than softening. The emotional weight of Prince Harry's testimony still lingered, but the proceedings were about to take a different turn. This was no longer about how the case felt. It was about how it held up. The follow-up witness entered without spectacle, without visible nerves, and without any need to persuade the room emotionally. She did not arrive as an adversary, but her presence immediately raised the legal pressure. She was a former assistant with professional ties to the publication at the center of the dispute. When she took the stand, her posture was composed, her tone steady. There was no visible anger, no defensiveness. She answered questions as if recounting ordinary facts, which in a courtroom can be far more persuasive than passion. Her testimony focused on a specific article published several years earlier, one Prince Harry's legal team had argued could only have been produced through unlawful surveillance. According to Harry's sworn account, the information used in that piece appeared shortly after the birth of his son, Archie, and there was no reasonable way the press could have known those details without intrusion. Timing was everything. The witness's recollection disrupted that narrative. She spoke in dates and locations, grounding her answers in small, concrete moments rather than broad impressions. She described overhearing sensitive details during a private lunch attended by freelance journalists, a setting where information was discussed openly, not secretly obtained. There were no recordings, no hacked messages, no intercepted data in her account, just conversation. More importantly, she placed that conversation earlier than the timeline Harry had sworn to under oath. The contradiction was subtle, but its implications were serious. Earlier, the court had watched Harry struggle with hesitation, searching for clarity on basic personal facts. Now, this witness, with far less emotional investment in the outcome, recalled specific sequences with ease. She did not need sympathy to sound credible. She needed only consistency. The moment everything slipped, the courtroom had settled into a tense hush, the kind of silence that presses on the chest, heavy and unyielding. Every eye was fixed on the witness, who for a moment seemed to carry the weight of the entire trial on her shoulders. When the judge leaned forward and asked her to clarify one detail, the room waited, collectively holding its breath. She paused, looked directly at the judge, and then spoke. "I don't think he remembers saying it." Those words hit like a hammer. Across the room, Harry's hand froze mid-gesture. His pen, the small tool that had accompanied him through every meticulous note and careful answer, slipped from his fingers and clattered onto the polished wood. It was a quiet sound, almost trivial. But in that courtroom, it screamed defeat. To the untrained eye, it was just a pen falling. But for anyone paying attention, it was a symbol. Control, however fragile, had evaporated. In a bench trial, where there is no jury and every decision rests solely with the judge, consistency is everything. The moment Harry could not account for a single line of conversation, the judge was forced to confront a glaring inconsistency. Pain, stress, or personal turmoil do not weigh on the scales here. Only credibility does. And in that instant, credibility faltered. The courtroom seemed to shrink around him, every detail suddenly sharper. Harry's carefully constructed narrative, the one he had labored over for months, was unraveling, not because of scandal or sensational headlines, but because of one simple, unyielding truth. Memory had betrayed him, and in a bench trial, that is a defeat that cannot be mended. What followed was subtle, almost imperceptible to the casual observer. The judge continued with measured questions. The witness remained composed, and yet the shift had already occurred. Authority, the quiet force that underpinned every statement Harry had made, had slipped away. He lost control over how his story would be received, how it would be believed, how it would stand under the piercing scrutiny of the law. Outside, the media might have spun their narratives, painting the drama in sensational colors. But inside the courtroom, it was far more profound. This wasn't a question of tabloid headlines or public opinion anymore. It was a question of fact versus falter, of whether the court could trust the man at the center of it all. And as the witness's words echoed in the silent chamber, it became painfully clear. For Harry, this moment was no longer a minor stumble. It was the line that no lawyer, no amount of preparation could ever undo. So, what do you think caused that courtroom silence? Pressure, memory, or something darker? And what does it mean for Harry's case? Share your thoughts below.